to your weekly community service show, Your Business Matters with Pallavi Ahluwalia of Ahluwalia Law Offices. Tune into their show between 10:30 a.m. and 11 a.m. every Wednesday on 104.9 FM and ask her all your legal questions. Ms. Ahluwalia owns and operates Ahluwalia Law Offices PC. She received her law degree in 1996 from Southern Methodist University in Dallas, Texas, and also has a graduate degree in English Literature and Master of Philosophy in English Literature from the University of Punjab, Chandigarh in India. Ms. Ahluwalia is also a certified mediator and has served as an appointed mediator for Collin County Courts. In addition to regularly volunteering at legal aid clinics hosted by the Legal Aid of Northwest Texas, Ms. Ahluwalia serves as a legal advisor to Chetna, a non-profit organization working on issues related to domestic violence. She also spearheaded and participated in the inaugural annual legal aid clinic that was held to benefit the underprivileged South Asian community. Ms. Ahluwalia also served on the North American South Asian Bar Association's Executive Committee and is the founding president of the South Asian Bar Association of Dallas. Her speaking engagements have included being the speaker at the National South Asian Bar Association's annual conference, speaking at the conference held by the Texas chapter of the American Immigration Lawyers Association, and a presenter to the Indo-American Chamber of Commerce activities. She has been featured in Texas Lawyer magazine for an article on law firm ethics. Ms. Ahluwalia speaks English, Hindi, Urdu and Spanish. Her office handles cases involving immigration and naturalization law, family law, business law, contract law and civil litigation. She can be contacted directly at 972-361-0606 or pallavi@yourdesilawyer.com.
If you log on to ahluwalialaw.com, that redirects you to DCLawyer.com. So yes, there is a lot of information that the website shares. Do log on to that website. The number to reach them is 972-361-0606, and you do need to call this number to get an appointment with Pallavi. All right, ladies and gentlemen, get ready to welcome Pallavi Ahluwalia on the airwaves of Fun Asia Radio 104.9 FM. This is Your Business Matters with Pallavi Ahluwalia. The number in the studio, 972-235-5555. Once again, 972-235-5555. Good morning, Pallavi. How are you?
A wonderful morning to you, Miss. I'm doing extremely well, and thank you so much for hosting me on this Wednesday morning with Your Business Matters. Glad to be here and to be able to answer questions for the community. We missed you last time. I know you were out a couple of weeks, and we're glad to have you back.
I am glad to be back as well, and I see number of lines lit up. So should we start with taking the calls?
Sure, absolutely.
Let's do that. Fun Asia Radio, you are live on the air. Go ahead and ask your question to Pallavi.
Hi, good morning, Pallavi. I have a question regarding my I-140. My employer will be applying for my I-140 very soon. The question is, I have, from my previous experience letters, I have 2 experience letters that are overlapping by a week time, and my immigration lawyer had asked for a reason. I went back to check on those letters, and those companies are right now closed. I wish to consult for companies, and those are closed right now. So will there be any problem with the I-140 application?
Are these in the U.S. or outside of U.S.?
No, all the companies are in the U.S. or where in the U.S.
Okay.
The two that were closed.
Yeah. So you must have been in some status, right? So your status would have terminated with one and started with another one. That's the one that I would put as the end date on the perm. So is the perm already been certified?
Yes, the perm has been certified. The process of I-140 has been initiated.
Along with the overlap on the dates, it's certified with that issue being marked on the perm, or it's not?
I'm not too sure about that.
Yeah, so whatever we have in the perm has to be authenticated. That's number one. And the other important thing is that you must have, if you ask for 2 years or you ask for 5 years, that should be visible in employment letters. Now, just having a week off, and if that question is asked, so they should be, you should have it flowing along with the perm, but just in case you don't, I think, and you have a good justification for it, you can provide justification. If you have pay records, anything else that shows where you were, then that discrepancy can be explained. That's the way I would handle it for right now. I wouldn't worry about it, but I would track to see if it matches the perm or not.
Okay, and one other question was regarding the same. There was one company that I worked for 2 years in India, and I did not exit that company correctly, and I came back to the United States. But I initiated the exit process after coming here, so they gave me an exit date of almost 2 weeks after I came to the United States. So will that also be a problem?
So you resigned after you reached here, so you have your resignation and you have an employment verification letter, right?
Yes, but the problem is I started working earlier.
Right, so the minor issues with a week or 2 weeks here or there, as long as you have over the time that you have asked for in the perm, should not be something that you should worry about.
Okay.
So if there's just a tweak of a week or 2 weeks, that should not be a big gap. Of course, you have to get past the 5 years or the whatever time that you've asked for in the perm.
Oh, okay. Yeah. Thank you so much, ma'am.
All right. Thank you for your call. 972-235-5555 is the number in the studio. This is Your Business Matters with Pallavi Ahluwalia. All right, you're live on the air. Go ahead and ask your question, please.
Oh, hi, Ms. Ahluwalia. Thank you very much for your service to the community. I have a question about H1 transfer and overlap between jobs during the transfer time. I'm a physician working for an employer. I got an H1 approved till the September next year. But I wanted to change job, so my new employer is filing it under premium. So they want me to start on the 7th of August, and my current employer is okay, but he wants me to stay till the 29th of August. So I work in shift system, so I would be able to work for both of them during that 3 weeks. Would that be a problem?
So a couple of things. Premium processing is no longer available. So if are you in an H1B?
Yeah, H1B, but I think for physicians they've just opened it, so the premium processing.
Okay, so you are being able to tap into premium processing. We have not.
That's what my employer is telling me. Yes.
Okay, yeah, I don't have that update. So what I would say is that if it is something that you can deal with in terms of 1.5 times of work, then you're allowed a concurrent employment. So what I'm trying to say is that you're allowed to work 1.5 times, but not 2 full-time jobs with 2 different employers. So concurrence is allowed. However, when you're doing a transfer, and based on that transfer, if you start working immediately, that is also allowed to you. So it depends on how that H1B is being argued, whether you're putting in, if you're putting in, concurrent employment on it, or you're putting in totally as a transfer, and depends on the date of the transfer. So I would say the 3 weeks in all should not impact you negatively, because in the time that you have, that is not of that much significance. However, you have to be aware that what the law allows, which is 1.5 times of work, and that too, it has to be stated correctly on your application as a concurrent employment, and not as a transfer.
Oh, okay. Thank you, ma'am. So only thing is, I think they are going to apply as a transfer. It's not going to be a concurrent. So once they put the start date as 7th of August on the transfer, and if the new approval notice comes in with that date, so would I still be able to do some shifts with the old employer? The old H1, would it get cancelled, or would it remain valid until it is revoked by the employer?
So the old H1, the withdrawal of that will be done by employer 1 for it to be invalid. Otherwise, it is assumed to also exist in parallel.
Okay, so do you think it shouldn't be a problem just working for 3 weeks simultaneously? Okay, great. Yeah. Thank you very much.
All the best.
Thank you for your call. Going on to the next caller, Fun Asia Radio, you're live on the air. Please ask your question to Pallavi.
Hi, yes, Rajkumar.
Yes, go ahead, please.
Hello. Yeah, I have a question regarding the new rule came regarding I-140 this year in the beginning. So let's say if a person has I-140 approved and he stayed for 6 months with the current employer, and then he moved out of that employer. So with the new employer, he has to again file perm and I-140, or he can stay until the priority date becomes current.
No, so that priority date is something that will move with you after 180 days, and so will be the ability to be able to use that I-140 approval for AC-21 based extensions of H-1B. Okay, those are the benefits of the new law that was announced in January of 2017. However, to get your green card with employer B, say for example you after 180 days have moved to employer B, anytime prior to your priority date getting current, you'll have to have that employer do a perm as well as an I-140 to be able to enable you to file your 485.
Okay, so in that case, he can, at the end when the priority date becomes current, but before that, using the employer's I-140, he can file the extension a number of times.
You can file for an extension repeatedly, even if that I-140 is withdrawn, as long as that I-140 had been originally approved for at least 180 days and was not withdrawn prior to that.
Okay, got it. And the employer B, ultimately when the priority date comes current, employer B has to file from the beginning perm and then I-140.
Correct.
Okay, got it. Thank you.
Thank you for your call. Once again, the number in the studio, 972-235-5555. Going to our next caller, Financial Radio. You're live on the air. Go ahead and ask your question, please.
Hi, Pallavi. Thanks for taking my call. My question is, my wife's green card is expiring this November, and we are traveling to India next week and coming back mid-August. So is that fine? Because I'll reapply for renewal once I come back. Is that okay?
Yeah, it should not be a problem at all as long as she has green card status. Even if that status expires, it still remains her green card. The suggestion, however, always is you're eligible to process this 6 months prior. So go ahead, process it, get your premium processing done, have that with you. In terms of CPP allowing you entry, that should not be an issue at all, even if it is expiring in 1 week. The government is supposed to allow you entry on that green card.
Yeah, because I'm planning to apply once I come back, because, the fingerprinting, if it comes in between, so I don't want to take that chance, So that's what I thought, once I come back, I'll apply, because I still have 3 months.
All right, yes, that's fine. Just be aware that the processing of the I-90 is taking up to 14 to 15 months. So the earlier you start, the better it is. So we call upon everyone that has their green cards expiring to be aware and just do it 6 months prior when you're eligible.
Okay. Thank you so much, Pallavi.
Thank you for your call. Once again, the number in the studio, 972-235-5555. Do want you all to know, if you want to see Pallavi beyond the show, you must take an appointment. 972-361-0606 is the number. And any question that you have now regarding, employment and family-based immigration matters, family law, corporate law, civil matters, give us a call right now. 972-235-5555. Number in the studio. Go ahead and ask your question to Pallavi, please.
Hi. My question is, my husband has a dismissed case. It was a misdemeanor case and we are on H1. Will that be an issue if we go for stamping?
So is it a misdemeanor A, B, or C?
It's a A.
All right. Okay, and I would not want to ask you questions pertaining to criminal law here right on the air, but all I can tell you is misdemeanor A can be an issue depending on what kind of crime it was, what kind of misdemeanor it was.
It's a dismissed case and it has been dismissed for more than a year.
So was he found not guilty, or was it because he took deferred adjudication or took something like that? So if he declared the fact that he was guilty and he took deferred adjudication, that is regarded as guilty for immigration purposes.
No, it was like not guilty and dismissed.
Okay, which means he was not found guilty, correct?
Correct.
So he was charged but not found guilty.
Correct.
Okay, and in that case, it should be fine.
Okay, and what kind of papers do we have to take if we have to go for stamping?
I would take the entire file from the charge, the arrest, and whatever happened and whatever the judge's order was. I would take the entire file. I would take a certified copy of that record. So I would ask you to go to court and obtain a copy and then go outside. You don't want to be stuck there looking for certified copies if the consulate so requires.
Okay. Thank you so much, Pallavi.
All the best.
Thank you for your call. Going to our next caller, Fanisha Reid, you're live on the air. Please ask your question to Pallavi.
Yes, ma'am. This question is regarding my wife. She is on H-1B visa, and on February of 22nd of this year, her doctor put her on medical leave. She was pregnant at that time, and she had some complications. And then she delivered the baby on 1st of June, and now she's on maternity leave. So she had an extended period of time off. So the question is that, she does have a job to go back, but she is not in that state anymore. She moved because of my job being moved to Texas. So we are in Texas right now, and now she's looking for a transfer. But for the transfer, she didn't have any payroll since February, and she's still on H1. But on the good side is that she does have her paid time off, and in paid time off she has up to 80 hours of accumulated time off. So she would be able to get her payroll run after she comes off of her maternity leave. So will that be an issue for the transfer?
Yeah, as long as it could justify that what she had was medical leave, and it is given to all employees of that company, regardless of their immigration status, and she has proof of the company policy that she was on maternity leave or had taken unpaid time off because she had some medical issues. She should be alright. She should be able to defend it.
The company that she used to work for, that offered the short-term disability, although she had to pay her portion for the insurance. So the insurance did pay for her time off, like the 50 or 60% of her wages. So she was getting some payments through the disability company. So will that work as a proof as well?
So everything that you can gather that shows that, so the concern that the government has is that people should not be out of status as in benched. Okay. So basically that they are non-productive and the company has forced them to be on the bench. As long as it's a justified reason that it applies to all employees of that company, it can be defended. So it should be all right.
Okay. So when she applies for the transfer, she needs to submit all her medical records and all the documentation that she has, right? So they do look into all those things, right?
They have the ability to look for those things. So she would just say that so she can put a separate section, and the attorney can argue that she was she did not go to work because of this medical emergency, and then she had maternity leave, and then she went back to the company and cashed out her pay time off, and now she's applying for this transfer. It should be fine.
Okay, sounds good. Thank you so much for your help. Appreciate it. Thanks.
Thank you so much for your call, and for all the callers, I do want you all to know, because we have just 6 minutes left. I do want to make that announcement beforehand that Pallavi will be back on air tomorrow between 10:30 to 11, right, Pallavi, to attend all the calls?
Yes, I will be.
Yeah.
Yes, I will be back. I do have a quick announcement before you take the next caller. The premium processing has resumed only for Conrad 30 waiver program for physicians. So that's a qualification for the physician that was on the air for premium processing. So Conrad 30 waiver programs are the ones that are allowing premium processing only at this point. And also one more thing that I wanted everyone to be aware of, if you could go on to aluwalialaw.com or for your ease, yourdesylawyer.com. You should also, our latest blog is how to protect my child in case I'm deported. This is some information that pertains to family law related options for people that may not have legal status. We know that SB4 is going to be the law of Texas starting from the 1st of September, and I just want everyone to be aware of this. How to protect my child in case I'm deported should be able to tell you what needs to be done in case you don't have your papers, what kind of papers you should have signed and have available with you. So I just wanted to give some information there. We just posted it yesterday, this morning. And me too, I can return to taking calls after this right now.
All right, perfect. I think as soon as we announced about that, people thought we are ending the show, but we are not. We are still taking your calls for next 5 minutes here. 972-235-5555 number in the studio. And yes, Pallavi will be coming back on air between 10:30 to 11 to answer your calls once again. There are so many calls always that we get, and there are so many unanswered calls, and we really apologize for that because there are people who ask so many questions. Sometimes they are longer than we would have wanted them to be, but nonetheless, we always appreciate, Pallavi, for you to come on air and answer them all in such detail. Well, let's...
Of course, my pleasure.
Okay, going back to the calls. Fun Asia Radio, you're live on the air. Go ahead and ask your question very quickly.
Hi, my question is, I have just filed for I-485 for me, for my wife and kids, and we have done a biometric. It is not, and we have applied for advance parole as well. We have not received it, but we want to travel to India, and we have H1 and H4 visa. So I've been reading on the forums that this is you don't need advance parole if you have H1, H4.
Okay.
So I just wanted your opinion on that.
Yes, so the H-1B, the L visa, they are dual intent visas. They allow you to travel while your adjustment is pending. This is unlike other status. Other people with status that have applied for an adjustment of status who can only leave upon getting an approved advance parole in their hand. Yes.
So I should be good there, right?
Yes, you should be all right.
All right. Thank you so much. Probably one last very quick question that we can take on air. You're live on the air. You have to be really quick with your question. We have very little time left.
Sure. So my question is that I'm a U.S. citizen here, and I applied for my parents' green card application last year and has been already approved. And I have a graduation coming up in December, and my parents still have a visit visa valid, and I would like them to attend my graduation on the visit visa. Would that create any issue when they enter United States since their intent is different?
When you said they've been approved, once they've been approved, but the NBC process been approved.
Hello,
do they have an immigrant visa stamped on their passport already or not?
Yes, they do.
So then they cannot use a visitor visa. They have to come in on the green card.
All right. Do you know that how long does it usually take after the application has been approved to get the green card?
So that was my question. Maybe we lost each other in the translation. The immigrant visa so that is a green card. There is an immigrant visa that's been stamped on the passport that is akin to a green card. Needs to enter the country within a GPA and wait here to get a copy of this. That is.
I'm not sure if our caller could hear that. For some reason, Pallavi, you're breaking.
I was not able to hear you.
Okay, Pallavi, you're breaking up for some reason, and we have exactly 40 seconds to go. So, do you want?
All right. So my answer, and Mita, if you can hear me, could you just go ahead and translate this as well, or just
it's absolutely.
Just restate it?
Pallavi, go ahead. Yeah, we can hear you now. Go ahead.
Okay, perfect. So the call here is the immigrant visa is already stamped on the passport, and your parents have to enter with the immigrant visa, and they have to come here. Their biometrics will be done at the port of entry, and they have to come here and await that green card in the country. the physical copy of the green card. But that immigrant visa, which you said was already on their passport, is the proof of their green card.
10 seconds on the clock. I think that answered your question. And thank you, Pallavi, and talk to you tomorrow between 10:30 to 11. She'll be back.
You're listening